Hello. The Divine Code reading for January 13th, pages 439 and 440. We're finishing up the chapter on laws of intentional and unintentional killing and killing through negligence or under duress. Topic number 17. A blind person who mistakenly threw a stone into a place where people are not commonly found. In a situation where a seeing person would have needed to go into exile to atone for this action, the blind person is exempt, since his blindness puts his act in the category of an unpreventable error. So okay. There's three different categories of location. One is like a public area where we expect there to be people. The other one is a semi-public area where we don't expect there to be people. It's like in a back area, but the public does occasionally go through. And then the third area is like out of the boondocks where nobody would expect anyone to be there. You know, he's out in a faraway place. Now, if he's in a boondocks area, the blind person's out in the middle of nowhere where people are not normally found there. You would not expect someone to be there. And he throws a stone, and the stone hit a person and killed a person. This person happens to be there purely by happenstance. He's there, and the person is injured or killed by the stone. The blind person would be exempt because he would not expect there to be someone there. There's no reasonable necessity for him to be concerned. Now, a person that's has his eyesight and is able to look, and they can see that 1 in a million chance that a person's there, they should be able to see the person. We're talking about the 1 in a million situation. A blind person would not be held accountable for that. A person with sight would be if the victim is in the line of sight. If a person with sight were to push over a wall, and there was the 1 in a million chance there was someone on the other side of the wall, the person, even with his sight, would be exempt in that case also, because it's people were never there. So that would, this is just another example. This would be another example of how, this third category of the total wilderness area where you'd not expect someone to be there. Rambam, The Laws of Murderers, 6:14. Topic number 18. Within Torah law, one who killed an enemy by mistake did not have permission for the protection in the city of refuge. Since it can be assumed that the killing was done intentionally, Rambam, The Laws of Murderers, 6:10, this law refers only to exile in a city of refuge and not to judgment in a court of law. So there are times when we're in human situations where we have to lean one way or another. If something happened among two people, an accident happens among two people, and the two people are friends, we assume that there was no malice. If something happens between two people and the two people are enemies, the assumption is that there was malice on some level that can lean a uncertain case one direction or another. And while this is happenstance evidence, it can be a factor. So even though we would prefer to lean on the side of expecting the highest level from a person. If people were enemies, and I would suggest that um, if the defendant in this case is known to behave based on being an enemy, then the assumption would lean more against him, towards the guilt in this case. Um, and that's regarding whether or not he's allowed in the city of refuge, which a certain amount of that is based upon, for a non-Jew, is based upon um, whether or not the person is going to be able to rehabilitate in the city of refuge. And it would not be in a judgment in a court of law, because this is happenstance and evidence, and happenstance evidence would not be accepted in a Jewish court of law. The rules are a little different in a non-Jewish court of law, therefore it may or may not be a factor for a court of law. In a Noahide base, then it may or may not be a factor. We'll learn that in the later part of this book. Topic number 19. Whether the word exempt is mentioned in this, wherever the word exempt is mentioned in this chapter, the reference is to an exemption from punishment in court, just as another person who sits through any other person who sins through unpreventable circumstances. In such cases, a blood redeemer has no permission to kill the accidental offender, and if he does so, he himself is considered a murderer and is liable for capital punishment. Rambam, The Laws of Murderers, 6:3. So the person would not be allowed if the person is exempt from punishment, the blood redeemer would also not be allowed to go after the person. The underlying purpose of a blood redeemer is to push the person into a court. If the court is going to find the person exempt, then the blood redeemer would not have that permission. Oh, also, I missed a footnote on concerning the courts of law, so maybe it does explain it here. In a court, this would be deemed unintentional manslaughter for a Jew or Gentile, since in this situation, no more precaution could have been taken. However, the assumption is that there would be some degree of intention involved, for which going into exile in a city of the refuge would not atone. So that this rule is, I guess, he's referring to the unintentional. Yeah, this is the middle the middle two categories of where it's an accident that is on some level of negligence. If it's nearly intentional, that means the person was doing something in a reckless manner that's liable to cause damage and could be expected to cause damage, then he would be treated as intentional. So the totally unintentional manslaughter would be the broader category, where it's just sloppiness on his part. He should have been more careful. He was not expecting it to happen, but it does happen. Sometimes these things happen, and the person has to be more careful. In that case, was the intention a factor, or was the mental state a factor, such as if the person is a friend or an enemy? And again, I would suggest that it needs to be looked at more carefully in the laws of the courts of justice. It'll be handled further in this book. Topic number 6. The prohibition of causing personal injury or damage. Topic number 1. It is forbidden to murder. It is likewise forbidden to harm any person. Panim Yosef Lekha, Kedushi Halacha, end of Tractate Kedushim, Lukute Sikut, Volume 5, page 146. So the question is whether we're not allowed to murder, and that's one of the 7 no-hide laws. Now we're looking at the question of injuring a person or causing damage to a person. Panim Yosef learns this from Tractate Bava Kama 91b, which explains the verse Genesis 9:5. But your blood of your souls I will demand. So this is in the laws given to Noah, when the instructions given to Noah when he leaves the ark, and in the instructions it includes the prohibition of murder. But your blood of your souls I will demand, to mean that it is forbidden to injure another person. Although the Talmud, that's in Bava Kama 91b, rejects this claim, claiming that murder is forbidden and as a distinct form of injury. Since its final statement is that injuring is forbidden, it is possible to say that this is the source for its exegeses. So the Talmud is looking at different questions, and the question is that if we're learning from this verse that injury is forbidden, and normally we learn from this verse that murder is forbidden. But the fact that the Talmud rejects an idea means that there was the idea, which means that there is some legitimacy to the idea. It's not, when something is rejected in the Talmud doesn't mean it's wrong. It means that it's not the normally utilized interpretation. But the other interpretations still have value. Surely the words, but your blood, etc., implies it is forbidden for a Gentile to injure another person, even himself, since this verse also refers to suicide. The explanation of this verse from Rashi, Ibn Ezra, and Sforno, and see part 4, footnote 35 above. That was the earlier in the laws of prohibition of eating the limb of a living animal, is that although it is permitted for a Gentile to kill an animal for human needs, it is forbidden to kill a human for the same purpose. So Noah, okay, before the flood, people only ate vegetation, fruits, grains, and such. They did not eat animal flesh. And there's some interpretations they may have eaten animal flesh that died on its own, but other interpretations, the normative interpretation says that they didn't. At the time of Noah, at the end of the flood, Noah was given permission to eat animals. And it's logical at that point to say, okay, we were allowed to eat animals, but not humans. Because otherwise you might think, okay, I can eat humans also. Now I can eat meat. The humans are meat. So God explained, okay, you can eat animals, but do not kill humans. Do not injure humans. From this, it can be learned that since even an animal which is permitted to be slaughtered may not be treated inhumanely by cutting off a limb before its death, then surely a human whose murder carries liability to capital punishment must not be injured. In other words, the prohibitions against causing needless human suffering can be learned from the prohibition against causing needless suffering to animals. And that'll be in chapter 7 on the prohibition against eating the limb of a living animal. Also speaks of not causing suffering to animals. Now, it could be a question: are we learning not causing suffering to animals? Some people would say that that's the reason for the prohibition against eating a limb of a living animal. There's technically not part of it. There's no prohibition. There's no biblical prohibition, clear cut. Pardon the pun. Biblical prohibition against severing the limb of a living animal or even causing suffering. It's that's just assumed as being a decent human being. We don't do those things. So perhaps because there is still a connection regarding the causing suffering to animals and eating the limb of a living animal, there's a connection there. Therefore, there might also be seen as a connection between not causing injury to a person and being connected with the prohibition against murder. Now, it might also be that injuring a person could be connected with the laws of damages that would be probably under the auspices of the commandment to have courts of law. So there's different aspects of this. Right now, we're looking at the aspect of injury being injury and not being damage. So for the sake of discussing injury as injury, it would fall under the general category of prohibition of murder. So it's connected, but it's not, the topic is not completely connected to murder. It can also be connected to the laws of the courts, requirement to have courts of law. It is forbidden to harm any person, whether male or female, young or old. This also applies not only to physical harm, such as wounding or bruising, but also to emotional harm, such as scarring, terrifying. See Tractate Bava Kama 56a, Rambam, Laws of Injury and Damages 2:7. Or embarrassing a person, for example, stripping a person in public. It includes causing suffering. See, Rambam, no, I'm sorry, Rabbi Zalman Nehemiah Goldberg notes the following point. In chapter 8 below, that's later in this area of the unit on the prohibition of murder, it is explained that this is part of the Noahide prohibition against murder. It is logical that all types of physical injury can be likened to stealing. As we see from the Torah, the beginning of laws of injury, Kosher Mishpat, chapter 378, and Rabbeinu Yonah on Tractate Avot, that's Ethics of the Fathers, 1:1. It is questionable if embarrassment can be considered like stealing. Although the Torah obligates a Jew who embarrasses another to make restitution, even though there is no monetary damage. Minhag Chinuch, Commandment 49, Part 38, leans towards the ruling that a Gentile cannot be liable to make restitution for causing another person embarrassment. See Part 7b, that's in Volume 2, that'll be the laws of stealing. Topic 11, 1-2, and footnotes there. So issues like embarrassment, damages, and all that, it's kind of sitting out there. It's not really directly part of the Noahide laws, but it's sort of a connect with the courts of law, and the courts of law are likewise connected with all the laws. and all these miscellaneous things that are otherwise just kind of hanging out there without clear connections, they all kind of are wrapped up in the course of law. Therefore, we could see it connected with the laws of stealing. We could see it connected with the laws of injury. It kind of connects all the way through. There are a lot of real life scenarios deal with the various laws, and it's difficult to say it's in this law or that law, but it's kind of, it's there. And injury is one of the things that would be in the no-hide laws, but it's not easy to pigeonhole it into one law or the other because it's all interconnected. In real life, these laws are in practical usage, these are interconnected with each other. This book of Halakha is just laying it out in an organized fashion. It doesn't necessarily work that way in real time. This will be explained more thoroughly in chapter 8. It's a couple chapters down the way. The different types of damaging a person through embarrassment and such. All these types of harm are forbidden. One who raises a hand against another with intention to hit the person, even if he has not already done so, is called a sinful person. Now, we don't usually use this category in halakha, but it's more of a musar concern. But the person is a sinful person. It may be difficult to accept his testimony in court. There are implications to this kind of a category. And even if he has not technically done anything at this point, it would still he would be of less of a stature because of it. Tractate Sanhedrin 58b, Rambam, Laws of Injury and Damages 5.2. Thank you.